This is Liesl Pretorius, Legal Advisor to Freedom of Religion South Africa, commonly known as 4SA. Today I want to talk to you about a law that Parliament is considering making. The Parliament of South Africa is currently considering the Prevention and Combating of Hate Crimes and Hate Speech Bill. The bill proposes criminalising expressions it deems to be hate speech. For this crime, the bill imposes a jail sentence of up to 8 years. So what does the bill say hate speech is? In simple terms, the bill defines hate speech as an expression that 1. Is harmful or incites harm, and 2. Promotes or propagates hatred against 3. A group of people specifically listed in the bill. Given that being found guilty of hate speech can lead to being imprisoned for up to 8 years, the crime's elements and their definitions, such as the definition of the element of harm, is crucial. Currently, the bill defines harm as substantial, emotional, psychological, physical, social, or economic detriment that objectively and severely undermines the human dignity of the targeted individual or groups. Clearly, the bill's conception of harm does not only encompass standard types of harm, such as psychological harm or physical harm, which are relatively simple to objectively identify and quantify, but also subjective and nebulous concepts of harm. For example, emotional harm is essentially hurt feelings, which necessarily entails a degree of subjectivity. Social harm is a novel and ambiguous concept. Its meaning is not really clarified by the definition currently provided in the bill, which is detriment that undermines the social cohesion amongst the people of South Africa. It is true that emotional harm is accepted under the Promotion of Equality and Prevention of Unfair Discrimination Act, the so-called Equality Act. But the Equality Act creates a civil hate speech offence and proposes civil sanctions such as fines and public apologies. In contrast, the Hate Speech Bill proposes a criminal offence coupled with a sentence of imprisonment of up to 8 years for hurt feelings. 4SA is concerned that that is not appropriate and indeed harmful for South Africa's hard-won constitutional democracy. The Constitutional Court has confirmed that freedom of expression is of the utmost importance, not the least because it lies at the heart of a democracy. Another concern is the degree of harm required by the bill, substantial harm. In other words, not even gross harm or deep harm. This means South Africans risk being imprisoned for substantially hurting someone's feelings. Finally, the bill does not even require a clear direct causal link between the offending expression and any actual harm caused. All that is required is that a reasonable person who is aware of the context of the facts and the circumstances surrounding the expression and who sees or reads or hears the expression thinks that the expression could potentially be harmful or potentially incite harm. It is again necessary to distinguish the Hate Speech Bill from the Quilani judgment, which concerned hate speech under the Equality Act. The Equality Act does not require a causal link between the offending expression and any actual harm caused. But the Equality Act is a civil law that imposes civil sanctions such as an apology or fine. The Hate Speech Bill is a criminal law and imposes criminal sanctions. In other words, it results in a criminal record and state sanctions such as imprisonment. It is reasonable to expect that the threshold for a criminal offence is higher than the threshold for a civil offence, whether that comes in the form of requiring more objective types of harm, a more serious degree of harm, or actual proof that actual harm was caused. 4SA finds it extraordinary that in an open and democratic society that suffered through the brutality of apartheid's censorship and thought control, that it will be easier to go to jail for speech, should this bill become law of course, than to be ordered to apologise in terms of the Equality Act. The bill is currently being considered by Parliament's second house, the National Council of Provinces. It will soon be opened for public comment. 4SA will continue to monitor the process and alert you as soon as public comments are open.
Good day, this is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.